Hello, we are live. So, hello to everyone who is watching live. Hello, if this is a replay, please type in the comments that you're watching. It would be awesome. So, I am Dr. Hochman, Lara Hochman. I'm a family medicine physician. I still practice medicine, and I'm the CEO and founder of Happy Day Health, where I match physician owned private practices with physicians who are ready for autonomy, ready to take back medicine, ready to take charge of their lives. And today I am speaking with Michael Johnson. He's a lawyer, and you can you can find him at physiciancontracts.com. We are going to talk about non-competes today. So I'm going to hand over the microphone across the airwaves. Go ahead.
Well, thank you so much. I always love chatting with you and coming on and just sharing, just sharing real issues about physicians, physician contracts, and just physician experience. My wife's a physician, she's a psychiatrist, and just through our own experiences with navigating contracts, trying to understand how all this works, we've learned a lot. I created a law firm 5 years ago to try to create a place where individual physicians could go to get thoughtful legal advice about their contracts, to evaluate, negotiate, and sometimes enforce physician contracts. We're not going to talk about that, but that's what we do. Thank you so much, Dr. Hochman, for just a platform to talk about these things. I appreciate it.
Oh, you're so welcome. And I've had physicians work with Michael, and always a good experience. So let's first just get started talking about the new FTC ruling, which is non-competes are no longer viable. So great. Does that mean that as of today, non-competes are no longer valid?
Not as of today. Okay. Best case scenario here is that on September 4th, okay, if every we're going to get into the legal challenges, right? But if every legal challenge to this rule goes in physicians' favor or employees' favor, best case scenario is that it could be enforceable on September 4th. However, there's a couple or probably more lawsuits coming challenging the enforceability of this rule, basically saying that the FTC, we'll talk about what the FTC is, but the FTC maybe went a little bit too far, that they don't actually have the power to pass such a sweeping rule to knock out non-competes in every state across the country. So there's a lot of headlines that came out probably 2, 3, 4 weeks ago that really didn't provide the whole picture. Probably provided the really attractive headline that gets you to click the thing, but the more appropriate headline would be something more to the effect of, if all legal challenges are favorable, then 4 months from now there wouldn't be non-compete. So the FTC, this stands for the Federal Trade Commission. I don't know if a lot of non-lawyers really understand how this works or what they do, but they are tasked with protecting American consumers from anti-competitive practices, monopolies, that sort of thing. Okay. One of the things that they started looking at was just unfair non-competes. A couple examples were a non-compete against a Jimmy John's sandwich maker. It's like, come on, really? This is nonsense. Another one was against an overnight security guard making minimum wage. They don't have any. There's no good reason for that. So physicians specifically weren't really at the forefront when the FTC created this ruling. But there's also some potential issues with enforcement, even if it passes. A lot of major employers of physicians are actually not-for-profit entities. And technically, there's an argument here that the FTC's ruling does not apply to not-for-profit entities, that it only applies to the for-profit space. Okay, the FTC disputes that a little bit. There's probably going to be a bit of a litigation around this. But I was curious, Dr. Hochman, if you had heard of any folks that were working for not-for-profits that have gotten these letters, these emails from the C-suite saying, "Hey, by the way, we're a not-for-profit, so you can ignore all of this." Have you heard much of that?
I haven't heard that yet. I am sure it is coming. Have you seen people who've had that?
Several, several. I've had a few, like quite a few former clients that have reached out, and I try to keep in touch with folks that I've worked with over the years, and they'll send a quick email like, "Hey, just so you know, here's what they're sending out now," and it's pretty much across the board. A lot of these major healthcare organizations are using that as the like initial defense, right? We're not for profit, so we can still have non-competes. Let's talk about just for a moment how nonsensical that is. If non-competes are inappropriate for-profit, profit-seeking entities, Dr. Hard, like, do you see a reason why they should be enforceable by not-for-profit entities? Like, should our laws favor mega health corporations seeking not-for-profit status so that they can maintain their non-competes?
It reminds me of like a kid having an argument, like, oh, trying to find that loophole that doesn't really mean anything. Well, that's not fair because, it kind of reminds me of that. It doesn't seem to make sense. Um, it makes no sense. So, and to add to that, the not for profit hospitals are not actually not for profit. So,
Mm.
it seems
No,
very silly
like
to me.
there's a lot of profit being made. It's just not going to shareholders, not going to like owners of the company. It's going to other folks, the folks in the C-suite, or to vendors that provide essential services to not-for-profits. They can be for-profit entities. So it's just profits by a different name and a different path.
Right.
But I know that you work with a lot of small independent private practices, small, truly physician-owned private practices. And this rule would prospectively apply to them. I'm curious what your thoughts are with non-competes in this space. My opinion is that maybe the most appropriate use of a non-compete is actually between co-owners of a small business. If, let's say, you and I wanted to start a medical practice together, maybe we have different skill sets, different advantages, disadvantages, and we want to like tie each other together so that we both succeed together. And if we can just destroy the thing that we're building together like that because I want to open up shop across the street and start competing, that doesn't really make a lot of sense. I think that having small business owners be able to tie each other together for a reasonable amount of time, it can't get too wild. But I think that actually spurs economic growth, actually supportive. I don't know what you're hearing. What are your thoughts?
Yeah, my thoughts on non-compete have changed since I opened Happy Day Health. When I first went into us, I thought non-competes are terrible. They're all bad. We should never sign any. And, from the employee standpoint, of course, having spoken to so many small business owners, so many private practices, and pretty much without like every single private practice, their biggest fear is that their physician that they've put money into, they've lost money the first year of of the employment. If this person then loses their money that first year, maybe breaks even, and then they leave, take all their patients with them, and open up next door. So I do have an understanding of the non-compete from that standpoint. I agree with you there. I also think that there needs to be a point in which it doesn't is no longer valid. You've made your money back for the practice. You've profited, they've profited at some point, and I would say that's probably around 3 to 5 years. If you want to leave, that non-compete should just be, I would say, void. And, maybe don't open up shop within a 2 mile radius or maybe even 5 mile radius. But I don't think it makes sense, especially if, maybe you went into the practice for partnership track and maybe you're not a good fit business minded, in the business sense for each other, but you do want to
Sure.
open a practice. Now you're limiting them from that. So I agree with you. I think there is a place for non-competes within reason. Um, but I don't think that a non-compete should just be as long as you work for us, you're never allowed to go anywhere else. I think it does everyone a disservice, including the employee, including the patients, including even the employers themselves. I mean, who wants an employee that doesn't want to be there?
No, I agree. When what you're talking about is a sunset clause, basically saying this provision is enforceable for a certain period of time, but eventually the sun sets on the enforceability of this clause, and it goes away. For independent physician-owned private practices that are offering future ownership, I usually don't push back if they want to condition a non-compete on the physician staying for whatever the pre-ownership track is, usually 1 to 4 years, depending on the practice setting, obviously. And then also, if the practice offers ownership during whatever timeline is prescribed in the contract, usually these contracts will have some sort of mention about, future ownership opportunities. It's usually never like automatically enforceable by the physician. Okay, the practice owners will have the option of offering ownership or not, and I'm supportive of that. But if the practice employs the physician full time the way that they said they would for the time period prescribed in the contract, and they do a good faith, fair offer of ownership on the timeline, and the employee says no, I kind of get the point. Like, hey, we've done our side of this bargain here. Okay. We've helped you build up the practice. We're offering you co-ownership, and you're saying no. We kind of don't want you to be able to leave and practice close by. I can appreciate the concern on the practice's side, and then like on the other side, if the employee says, you know what, they guaranteed me a minimum salary for 2 years or 3 years. I don't want this. I have a better opportunity at this other practice. I'm going to go to that. I can understand the owners wanting some measure of protection there. I guess the counterpoint to that would be you can accomplish that similar protection under a non-solicit clause. We're going to talk about that when we get into our hypothet here in a moment. But how the non-solicit clause can often create the same thing. Like if they want to protect, if the practice wants to protect that physician leaving and opening up shop across the street and taking patients and taking advantage of referral sources and of like local hospital privileges and all the relationships that were developed during the employment, that can be resolved through a non-solicitation clause. New Mexico has this. You can't have a non-compete, but you can have a 1-year non-solicit, and that can often create the same outcome. But do you see many co-owners of small private practices that really think through or talk about the non-solicit as much as the non-compete?
They really don't. And I think a part of that comes to the education, educating someone. And, where this probably comes really into effect would be if the employer has an income guarantee from the hospital. And then they put this non-compete in, which is obviously not valid because of the income guarantee and everything that comes with that. But a non-solicit actually would make a lot more sense. And I'm going to take a note for one of my clients who is signing a candidate right now. I'm going to take a non-compete in. So
yeah, look, I think we're going to go through it on a hypo in a moment, but I think a lot of practice owners really should be looking at the non-solicit instead of the non-compete anyways. Okay,
really
just that
like
baseline.
That, yes.
But I also think that if non-competes fall, then all of the complaints, all of the concerns that the practice owners are currently, expressing can be resolved in other ways. I see like compensation clawback provisions for early termination. That's certainly an option. I'm not a big fan of those, obviously, because I represent physicians in early career. I don't want them to have to pay back money if they want to leave, but that's another option that's available. And then the non-solicit clause. But yeah, let's hop into a hypothet. One thing that I've seen a lot of recently, especially over the last maybe 3 or 4 weeks with the FTC's ruling, is folks saying, "Hey, let's get into this fight. I want a good fight." And look, I'm a litigator at heart. I love a good fight. That's great. But when we really break down what that fight would look like, I have a lot of physicians saying, "Oh, never mind. Maybe I just go outside of this, or maybe I look at other options." So I'd like to work through, if you're okay with that, Dr. Hochman, just an option for your listeners, for my listeners, just to walk through what a conversation like that would feel like, look like when you talk to a lawyer about violating a non-compete. What are your thoughts?
All right, let's do that. And I want to just remind anyone watching that if you have questions, you can type them in the chat and we will see them and we can answer them real time. So if you have questions, please type them in. If you think people need to watch this, type hashtag Michael Johnson. Type hashtag it. Let's do hashtag Michael Johnson. And then that'll allow us to reach more people. So in this hypothet, I'm going to be a physician trying to leave my practice. Is that correct?
Absolutely.
Okay. I'm going to
Yeah.
call you up.
Bring, bring.
Hi, this is Dr. Hochman. Who am I speaking with?
Yeah. I sorry, let me collect myself. I get a lot of folks that are reaching out that are looking to violate non-competes. If you would just tell me, for a little bit of summary about where you're at in your career and your goals and what you would like to do with this next step in your career.
Great. So I'm a family medicine physician. I've been in practice for 12 years. I've been working for this big mega health company. I have some family issues that I need to go take care of a family member, and I need to go part time while I do this, and they won't allow it. Um, and I'm actually getting this from multiple real conversations I've had. So I have a family member that I need to take care of. And because they won't let me go part time, family comes first, and I would like to leave. But I have a 25-mile 2-year non compete. And I need to stay local to be able to take care of my ailing parent.
I totally understand. Very common situation. As you probably heard, the FTC is attempting to ban non-competes. It's not enforceable yet, okay? It's May 14th, 2024. Certainly possible that it could be enforceable by September 4th. Our position, our expectation in the firm is that it's ultimately not going to pass, that the legal challenges are probably going to be successful in our estimation, or at a minimum, it's going to get clogged up in courts for an extended period. So we got to pay very close attention to that non-compete. Also, you mentioned mega health. About half of them are actually set up as not-for-profits. So if yours is technically a not-for-profit, even if the FCC ruling does pass, they might claim that exempts them from the non-compete. They might still try to enforce it against you. So let's really take a moment to just work through all of our options here and talk about what that challenge might look like, okay?
Thank you. Now that you mention it, I did get a message from our C-suite saying that we're not for profit.
Yeah, very common. It's the easiest defense for them right now, right? We get to ignore all of this because of our tax exempt status, and I think that's nonsense. But someone's gonna have to sue them. Might be somebody like me, but we'll see. But looking at a non-compete, 2 years, 25 miles. We're going to talk about this as if it's in Texas, but it's kind of similar everywhere that a non-compete is potentially enforceable. But we certainly have the option on the front end to just send them a message and ask them to voluntarily waive it. However, you probably already tried that. And a lot of times employers ignore requests from physicians unless it's put in writing or unless it's elevated to the C-suite level, or a lawyer puts it on their letterhead and sends the same message in a different direction. Who have you talked to so far about your request to go part-time or your request to potentially waive the non-compete?
I spoke with my boss, who is the CMO.
Gotcha. Okay. Look, a lot of these folks get a ton of requests from physicians all the time, and then they say no and nothing really happens. So we often have to, push a little bit further to see what our options are. Usually the first step here is for us to write a letter on our letterhead that explains what you're looking to do, the reasons that you're asking for a voluntary waiver of the non-compete. We write it out in a professional way, but we advocate on your behalf, okay? But write it out professionally and try to put it in the right hands. Occasionally, there's a physician compensation committee that might meet monthly for some of these mega healths that will sometimes have an input, a say over which non-competes they voluntarily waive or not. Do you know how this works in your institution? Is there a way we can kind of backdoor this?
Oh, I don't know how this works. I've never heard of it.
Um, we'll have to see. We'll think about it a little bit, but that would be step one. We got to talk about costs, right? I know that hiring a lawyer can be a little bit challenging at times. We do cost money sometimes, but in the firm we do almost everything flat fee except for litigation. Once we're in litigation, I can't really control costs. It's sometimes just completely outside of my hands, so I can give estimates. But before we get into litigation, I can do flat fee for everything. But for something like reviewing your current contract, really working through the details with you in drafting out a thoughtful, advocating letter to ask them to waive the non-compete, about 1,500 would be a good estimate for that, and we can clarify that as we go forward. But you don't have to make any decision about that now, obviously, but let's talk through everything. There are a couple other considerations, though, in your contract that might affect how we could advocate or potentially fight the non-compete. Could you tell me about your term and termination clauses? Do you know when you could terminate the contract without cause?
Let me look through my contract, which I happen to have right here. The year? I don't know.
So often we have a term that's 1 or 2 or 3 years, and often it automatically renews forever. Okay. And then almost every termination actually funnels through the termination without cause clause. In the firm, we really advocate for first contract physicians to have the option to terminate for any reason or no reason at all upon about 90 to 180 days of notice. If it's less than 90 days, it's really hard to transition to a new job without missing paychecks, right? If it's more than 180 days, then that gives like a living with your ex too long type vibes, and it can get a little challenging on a personal side to stick around, right? So we'll double check that in your contract, but if we end up suing them, we could sue them before you actually submit your notice of termination. That can sometimes give us a bit of leverage saying, hey, we just sued you. You have to keep paying the physician for another 90 or 180 days, even if you don't want them to be there. And we can apply a little bit of pressure that way. If it's like a 1 year no out contract, I highly discourage those on the front end, by the way. I want every physician to be able to leave, to have the option to leave. Okay. But if they put it in there, now we get to sue them and force them to keep employing you and paying you during the pendency of a lawsuit that I may or may not create a little bit of nastiness about. So we can sometimes add some pressure there. Okay, so we're going to take a close look at your termination clauses and talk about how that affects our options. Okay.
Do you see, sorry, I'm getting out of character here for a second. Do you see, if you're suing the hospital or the employer, what kind of backlash do you see or long-term things coming from that?
Being involved in a lawsuit is not fun. Okay. It's takes away your time, your money, your energy. If you can avoid it, I encourage folks to avoid it. I've seen family members of mine that have dealt with this, and folks that have been close to me, and it can really eat at you. So it's not something to be taken lightly. I'll also say this: there are a lot of employers that really don't want to hire a physician that's in the middle of suing their current employer, particularly over a non-compete. We got to look, Dr. Hochman, at your next contract. Okay, if it has essentially the same non-compete, then they might not actually offer you the job, especially once they know what your current non-compete says. And particularly if we have to file a lawsuit, we got to really fight something out publicly about your claim. Now, if it's a bit more private, if it's via arbitration, which is a private dispute resolution procedure, instead of litigation, which is public, then that might open up a few more opportunities for you. But yeah, it's not fun, and there certainly could be some issues with employers in the future potentially not wanting to consider that. But also, we have such a massive physician shortage in this country, and if it's just a matter of, hey, this non-compete is outside of the bounds of law, like, do they really have a good reason to be upset with you? Like, this is nothing about your ability to provide high-level patient care. It's nonsense. So I'm also a fan of saying that's not really a fear that you should, you should be, it should be your primary concern. Sometimes you should, do what's right.
Got it.
But yeah, so we'll look at the term and termination clause and talk about those issues. We want to take a close look at the non-solicit clause, though, in your current contract, because if the next position that you consider requires the same hospital privileges or the same referral sources, or maybe patients are wanting to come with you, or the practice expects some patients to follow you, or you want to bring part of your staff with you. I realize you're going to a part-time job, part-time position. So that's probably a little bit less likely in your specific situation. But what are your thoughts on that? Do we have a risk factor there?
Let me take a look at my contract. Oh, yes. I cannot solicit patients or take anyone that I currently work with.
That's very common. I think that employers are maybe even most sensitive about taking all of your coworkers. Like, it's really hard to hire physicians in, current healthcare, but filling MAs, techs, staff, NPs, PAs, that's even gets rougher. So I see maybe as much or more litigation issues around physicians that take their staff with them to the next position. So if you can avoid that, then I would encourage you to. But either way, it needs to be an issue that you bring up with your next position. They actually kind of need to know what the non-solicit clause in your current contract says, so that it can make appropriate accommodations. A lot of employers that are bringing on a new physician are doing it through either turnover. Okay, you're coming to replace a physician that recently left, and you're probably going to take over their patients-ish. Okay, or growth. They have too many folks that want to come. They don't have enough physicians. Very rarely are they saying, we don't have turnover or growth, but we want to hire you. I hope you find your own patients. Like, that's usually not how it works, right? So some of the concerns for physicians that are leaving a job wanting to bring their patients over with them are maybe a bit misplaced. It really just depends, though. And I'd say in a family practice environment, especially if you're changing practice settings, okay, you're going from mega health maybe to a small private practice, certainly have patients that will follow you and want to follow you, but that might not be a primary concern. But we're going to walk through that when we get there, okay? But the FTC ruling and various limits on non-competes really don't have a big impact on the non-solicit clause. Some non-solicit clauses can be so punitive that they are effectively the same as a non-compete, and I could see some litigation around that. That's a bit of an open question. So, that's kind of the background. Let's see where that goes, okay?
Thank you.
We should also talk about the timeline from your termination and how your comp plan lines up with that. Could you tell me a little bit about how your comp is? Is it flat salary? Is it like a base plus bonus, like a base plus productivity bonus model? And like when you get paid, I'm looking very closely at like when we're going to terminate this contract to make sure that you don't lose out on money. Could you share a little bit?
Yeah, I work on RVU bonus structure.
Gotcha. Sometimes if you don't have a minimum guaranteed salary under an RVU productivity-based comp model, then during your like termination notice period, some employers will treat you really unfairly. They'll pull your patients, pull your staff, pull your techs, pull everything, and they're making you kind of work, but you don't have any patients. I think that there is a general obligation of good faith and fair dealing during a required termination notice period. They put it in the contract, okay? They're the ones that drafted this thing, so they should treat you fairly upon exit. But I see a lot of employers not doing that. So we need to maybe put into, if we end up terminating your contract before we find out the non-compete or vice versa, we might want to put a note in there requesting that nothing happened to your patient load during exit. If you're paid purely on work RVUs, then that's how you get paid. So, not having patients might mean you lose out on money. It becomes a bigger issue if we have a really long notice period, 180 days. But if it's something shorter, 30, 45, 60 days, then the exposure is a little bit less. Does that make sense?
Mm-hmm.
Gotcha. So yeah, some other issues we need to pay attention to. Your 401k or 403b vesting schedule. If your retirement account contributions vest immediately, then great, we can ignore this situation. But sometimes the employer will require you to stay for like 3 full years, and then you get all of their contributions. So if you have like a 4 or 5 or 6% match, let's say on probably 250 to 325 as a family medicine physician, then that could be a 20 to 40, $50,000 issue. So we want to pay close attention to your benefits package. If it means staying for like a couple more months to reach that vesting cliff, then let's pay attention to it. How long have you been in this job?
I've been in this job for 2.5 years, and it's a 3-year contract.
Gotcha.
What
So
does that mean?
We're kind of on that edge, right? If there is a 3-year cliff vesting where you stay for 2 years and 364 days and you get 0% of the employer 401k match, but you stay 1 extra day and now you get to keep all of it, we might want to pay close attention to that. We might need to pull your benefits package and really look at that closely before we time out your notice. And look, I realize you want to get out of there, but if it's a matter of like a couple months and it's a $50,000 problem, that might be something to stick around for. Would that be enough to kind of make a difference for you?
That would make a difference. In fact, then I could actually take a couple months off to spend with my ailing parent.
Yeah, I think that'd be really good. You bring up the 3-year term. Okay. A lot of contracts have a initial term of 2 or 3 or 4 years. The vast majority of physician contracts that we read in the firm have what's called an automatic renewal clause, where they automatically update annually forever. So that 3-year term really doesn't mean much when it automatically renews forever. As long as you have a termination without cause clause, we're going to check it in your contract, okay, then I don't really care if it's a 3-year contract, 15-year contract, 150-year contract. Like, it doesn't really matter anymore because we can terminate without cause at any time. Also, the vast majority of contracts, like the non-renewal of the contract term, like clause, matches the termination without cause clause. So like if you wanted to non-renew your contract at the end of 3 years, you got to give usually 90 to 180 days of notice. In the vast majority of contracts, unless the lawyer on the other side kind of goofed it up, it has the same deadline. So it really doesn't matter in probably 90 to 95% of contracts that we read, but the other 5 to 10 really does matter a lot. So we got to pay close attention to that. Okay.
Great.
But yeah, just going step by step. What we'll do first is we'll go through the non-compete. We'll look at all these ancillary issues, and I'll create a more detailed plan. But step 1 would be for me to write about your contract and then create a first draft from my letterhead, helping you advocate for a voluntary waiver of the non-compete. We'll talk about a little bit of personal side, okay? I don't think that we have to, tell them exactly what issues your family is dealing with. We can leave it at that, okay? But understanding that there is a personal side to this, that it's not just a matter of you looking to create a competing business across the street as soon as possible, I think will be meaningful. If we could put into that letter that you're taking a part-time position because they don't offer that, that could be very powerful. Is that something that you'd be comfortable kind of committing to in a written document, in a letter?
Yes, because there's no way I would work full time at this point.
Gotcha. Okay. Sometimes too, whenever we send these letters, it gets into the right hands, and then folks are like, whoa, 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 we'll keep you, okay? We'll do the thing that you've been asking about for several months. So be prepared for that. If they came back after our letter and said, okay, Dr. Hochman, what do you need? Let's do that. Is this something that you want to stick with? Do you want to stay?
Yes, I do want to stay.
Okay. Well, I'm hopeful that that is the outcome here. And with that in mind, when we draft that request for a voluntary waiver, um, maybe I'll soften it up a little bit. I won't get too like lawyery aggressive, okay? But we got to say something about the potential to beat out a non-compete in court. Okay, it's just something we got to talk about. But I'll draft it with reconciliation in mind, if you will, and we'll see where this goes. But a lot of times with that first request, they'll also still ignore it, or they'll say, "Yeah, sure, we'll get you an answer right away," and then time goes by and no one really cares.
Can we choose your own adventure here? And I'm going to
Yes.
say, I would have wanted to stay, but since they don't seem to respect my family life and my personal issues, I have changed my mind. And no, even if they do say, okay, we actually do want you to go part time, I
Well,
don't think I would stay anyway.
at this point, we need to talk about like submitting your notice of termination, like within this document. If you want to reconcile, you just want them to do the thing that you're asking to do, then maybe we pause on submitting your notice of termination. Okay. But think about it for a little bit. Okay. These are weighty issues that you don't need to decide right this moment during our conversation. Sleep on it. We can talk about it tomorrow or later. But that will kind of maybe dictate whether we formally notice your termination. If we formally notice your termination, then I think it's most prudent for you to know what other options are out there. If there is a part-time locums deal that maybe is tele, some family practice opportunities that might be tele. With family practice, you're trained in so many different areas. You can do hospitalist work, depending on like the scope of your practice and what you want to do. Um, if we submitted a notice of termination and you decided at the end of this to not violate the non-compete, or they said like, no, we're still going to enforce it, we don't care about your problems, then what other options would you have outside of the bubble?
Mm.
I like contingency plans, right? You never know where these are going to go. So if you don't have a contingency plan yet, we need to think about that and at least have an option.
We need to talk about that at a future date. I'm taking
Look,
notes here.
locums opportunities, no,
Contingency plans.
contingency plans.
And I want to do a talk with you on partnership track.
Love it.
Okay.
So yeah, we'll set that issue aside and we'll address it during our next meeting after you've reviewed our physician contract report and you reviewed our first draft of your request to them to waive the non-compete. Okay. Let's talk about next steps. If you submit that and they ignore you, the next step would be to actually draft a lawsuit against them. Okay. We do this in the firm. What we find is that once you draft lawsuits and you start sending it to folks in the C-suite talking about a public potential issue with fighting a non-compete, a lot of folks don't want to fight that. They also just experience a lot of physicians that like huff and puff and then don't do anything. So if you actually show like, no, I drafted a lawsuit, here it is, you need to pay attention to me now. Sometimes that will create the appropriate internal leverage at these mega corporations to get the thing done. There might be some internal allies that says, hey, this is really dumb to ignore Dr. Hotman's reasonable request to go part-time or, pick up another part-time job within the non-compete bubble. Like, this is silly. But there might be somebody else that just says no, and having a drafted lawsuit in front of them could be more impactful. Okay. Most of the time, this lawsuit is what's called a declaratory judgment action. You don't actually have to like violate the non-compete to ask a court, or depending on your contract, if it's an arbitration clause to go to arbiter. We'll talk about that, okay? But you don't actually have to violate the contract yet to go to court and ask the judge to invalidate the non-compete. You can wait. So depending on what you want to do with the termination issue, like during the pendency of this lawsuit, like you could literally still be working with them. That creates some oddities, right? I've dealt with that before. I've sued a practice, and then the physicians are like doing a surgery together that afternoon. It's kind of an odd thing, but I don't know if physicians do this sometimes. You got to be prepared for every contingency here, okay? We'll talk about that when we get to that stage. A declaratory judgment action lawsuit, legal battle, is typically a bit shorter than your like standard lawsuit. We might be able to get this done in, let's call it 6 to 9 months if we're lucky. If the other side's legal strategy involves delay, which is quite common in legal disputes, if it involves delay, then it certainly could take longer than 9 months. I really can't control for sure how long it would take. But in most legal disputes, at least one side benefits from slow rolling the process. Okay. There's always like one advantage, one disadvantage. So there's always one that's usually pushing for a slower process. So we'll have to keep an eye on that, but you should be prepared for 6 to 12 months, maybe even more, of being involved in a lawsuit. You don't have to make a decision on that yet, though. You can draft the lawsuit and then we send it with another cover letter saying, look, I submitted my last letter 2 weeks ago. I didn't get a response, and then we would put in some additional details about what you're claiming. And we probably put in the lawsuit that you asked them to keep you on part-time and they said no, and you want to take another part-time job within the non-compete bubble, and it's for personal reasons, and you have family issues, and you don't have to get into every single detail about your family. Okay, I'm not going to put that in the lawsuit unless you tell me it's okay, but we're going to advocate, we're going to tell a story. The judge is going to want to know what the story is, what's going on around the non-compete, because that's going to inform them on whether the non-compete is reasonable or unreasonable. There's going to be a factor there. But additionally, as a family practice physician, I don't know that there's as strong of a business reason to force you to stay within stay in your job. Okay. If, let's say, you're a neurosurgeon, you're the busiest like surgical specialist that is really the linchpin behind a tier 1 hospital or tier 2 hospital or whatever, like you can certainly make up a hypothetical that it's very, very important to keep that physician in that place, right? But in family practice, if you're just an outpatient ambulatory, you're working seeing patients primarily, you're not in a managerial or leadership capacity, then I think that their like business justifications for keeping the non-compete in place start to go down a bit. But what are your thoughts on that? What do you see in your experience?
Yeah, I mean, I see similar for sure. I don't know.
Yeah, it's hard to say what they do, but step 2 in this process: draft the lawsuit, another cover letter that says, pay attention, here's what I want to do. Let's have a meeting ASAP, and we'll put some sort of deadline on it. For me to draft out that lawsuit, we're probably looking more at like $5,000 as costs. We'll have to see when we get there. Okay, I'll update this estimate as we go, but just to stay accurate on the cost, we're probably looking at 6,500, give or take, how this goes.
And that's just to draft the lawsuit.
That's just to draft it. So if you decide after drafting it, sending it to them, and they ignore you, if you decide to file it, we can file it, but I can't really do it under like a capped legal fee situation. I really never know how long it's going to go, how extensive the process is going to be, how many times we got to go to court, how many things we got to draft, how much information we have to produce. But I generally estimate somewhere between 20K and 40K.
Wow.
Maybe more. Their side is going to be a lot rougher. They have more money than you, Dr. Hochman. Unfortunately, they have more resources. They probably have several hundred contracts that have this exact same non-compete in it or very, very close to it. So they're going to be exceedingly motivated to win a legal battle. They'll throw significant financial resources behind that. So don't expect it to go quick and cheap. We got to also look at your contract for a attorney's fees and costs clause.
Huh.
Once we file that lawsuit, okay, many physician contracts will say whoever wins, or we can also talk about what a win in a lawsuit actually looks like. That's sometimes litigated itself, right? But if one side wins, then sometimes the other side has to pay their legal fees.
Wow.
Depends on what's in your contract. A lot of employer drafted first draft employment agreements will say that the winner of the dispute gets to recoup their legal fees from the loser in the dispute. So while you might pay me 25 to 50, let's say, if you lost, then they might claim you owe them their legal fees to probably be double mine, frankly. I wouldn't be surprised if that's the case. So now I think you need to be prepared, okay, for the potential contingency for a loss to not just mean you got to go 25.1 miles away for your next position, but to also potentially have about $100,000 expense associated with it.
Wow.
So yeah, we don't have to make a final decision on that right this moment, but we're going to have another discussion about this right before we file this lawsuit to make sure you're comfortable with that. We'll have to have a talk about your personal financial position, if that's an amount that you can come out of pocket for at this moment in your life, or if that is financially prohibitive, then we might need to consider a different path.
I'm going to break character for a second. I want to ask you something. If someone were to fight their non-compete, just say they get the backing of all the physicians in the country because we've had enough. Let's go find me all the funds to fight someone's non-compete. Would you foresee something like that getting all the way up into whatever higher up court it would take to make it so that non-competes are just not legal for doctors or something? Like, do you see
That is
that
a
going
very good question. We can actually go back into character to answer that. One of the things we need to be aware of is that whoever decides this matter at the trial level, let's say it's a litigation clause and we file a lawsuit, okay? That judge is going to have a ton of space to decide as they see fit. In the vast majority of states, there's like some cases that fall on this side of the line, some cases that fall on that side of the line, and they kind of fall based on their individual facts. Okay, so that judge is going to have a lot of discretion to decide your matter as they see fit. So the judge's like feelings about non-competes and about your position, the details, the facts of your case, and frankly, how they feel about you could have a significant impact on your outcome. That's going to be really, really hard to turn over on appeal.
Huh.
Winning an appeal on a non-compete would need to really turn on the law, like the judge improperly applied the law to the facts. We don't really get to rehash the facts themselves on appeal, okay? But we have to say that the judge improperly applied the law, which is a much more difficult like standard to go over compared to what the trial judge decides. So like I know like people get a little bit upset about political disputes, but we got to bring that up at this moment. Once we file that lawsuit, if the judge, if the court that we land in, if the judge frankly was elected on a very business friendly side, maybe more conservative, probably older, then look, the odds of them believing that non-competes are inappropriate and generally not wanting to enforce them is probably going to be lower. Okay. Now, if it's the opposite direction, it's the more liberal jurisdiction, if the judge was elected by a more liberal electorate that frankly doesn't really support non-competes, particularly against employed physicians, then look, odds are we'll probably have a better chance of winning, but turning that over on appeal is going to be exceedingly difficult.
Wow. That's interesting. That's very
Vote in your local elections on judges. If that's like the odd thing that comes out of this presentation, it matters. It really does, because everyone talks about, yeah, we'll appeal it and it'll go here or there or whatever. Those are really issues of like improper application of law, but not applying facts to law. Like that's where it gets a little bit more. That judge has a lot. Trial judges have a lot of power. So, but yeah, so that's kind of the overview of the steps. You kind of have like a 3-step process here. We got the voluntary option. We've got step 1 is voluntary waiver. Step 2 is drafting a lawsuit with maybe a little bit more aggressive tint to the cover letter. I can probably control the scope of your dispute if we are just in step 1 or step 2. Okay. Once it goes into step 3, it'll probably become public. Probably Becker's Healthcare will pick it up and write a bunch of articles about it, or it'll become a whole thing. And I never really know for sure where it's going to go. Now we got to look at your contract. If it's an arbitration clause, arbitration is a private matter. It's not public. You can't go search the arbitration lawsuits publicly the same way as you can a lawsuit that's like filed in litigation. All right. So most physician contract clauses will say that you have to pick an arbiter that is a member of the American Health Lawyers Association or some other particular group that frankly is probably going to be a bit more conservative on these issues. Okay. No guarantees here. All right. It really just depends on how this works out. But folks who are a part of that group are probably more likely to represent employers than individual physicians fighting against non-competes. So, that probably isn't a great venue just on the surface before you even know who it is. Probably not the best venue for you to fight this thing. So if it is arbitration, it's usually a little bit quicker, not a lot. Arbitration should be a lot faster, but it's really, became a lot more problematic to get things done quicker in arbitration. Over the last handful of years. It depends on your jurisdiction, obviously, but it might be a little bit cheaper, but maybe not. Like it's kind of coming to be about the same.
It's interesting. Well, there you have it. That's what it takes to fight a non-compete.
Yeah, and obviously this is like a hypothetical, right? Like this isn't legal advice. Like go talk to your own lawyer. They might have different opinions than me. They might have a different path. Every situation is different. But usually have to consider that. I encourage physicians, though, to have that talk with a lawyer that really knows about what they're doing. I ended up also probably talking myself out of legal fees in this discussion, right? You gotta think about that too. Like if I like, yeah, let's go find it. Like it's gonna cost whatever it is. Like just put some money in my account. We'll figure it out later. Like I would make more money if I pushed more folks into litigation. Okay, so consider this when you're talking to your lawyer about this, that they do technically have a financial incentive to encourage legal fees. But also as a lawyer, I kind of want to win legal disputes, right? Like kind of want to win. So if it's not something that I feel like strongly about or feel like it should be brought, then usually kind of steer folks away from a dispute. So keep that in mind.
Yeah, awesome. Well, there you have it. Michael Johnson, physiciancontracts.com. Go check him out because he's awesome.
Thank you. One thing I did want to bring up before we go, I've created a course on physician contracts. It's about 10 to 13 hours. We're in the middle of editing right now, so I don't know how long it's going to be. Okay, so somewhere around that area of listening to me talk about physician contracts. We have a detailed written section as well, and a lot of PDFs, a lot of worksheets. Hopefully creating the information, the course, the background that so many folks say we need and we don't get. Okay? Right. I do a lot of residency and fellowship presentations. And for the vast majority of those, my 1 hour presentation is all they get on physician contracts. And that's not good enough. It's not. So I want to resolve that. I don't want that to be a thing anymore. So over the next couple months, hopefully by August, it'll actually drop. And there'll be a course out there that really is targeted towards early career physicians, ideally even first contract physicians that are in training, that are getting ready for their interview process, that are trying to make decisions about practice settings, trying to figure out student loans, trying to understand what all this means. Like, I just want folks to go into these conversations kind of understanding what's up, right? So that's what I tried to create. So I'd love for folks to consider taking a look.
I'm excited to see it. I'll check it out for sure.
But
Cool.
yeah.
Well, thank you for joining us. It was good to have you. And I know this was very helpful. I took some notes here. So not just for my clients. For
The locums option is an important one, right? Because before we get into a dispute, I like for everyone to have a second plan, a third plan, a fourth plan, a contingency if things don't work out, and
Mhm.
locums can be that. I'm curious if you've worked with any folks, any employers that are looking for some tele options, or what do you see out there for tele options for family practice docs?
I typically don't see it from the employer side. I see it from the candidate side. There's more physicians wanting to do telemedicine than they are physicians.
Sure.
I think it's very indicative of the state of being a doctor today.
Yeah. Well,
Cool.
cool. Thank you.
Well, thank you. Physiciancontracts.com is where you can find Michael. And I'm Lara Hochman at happytohelp.co.